Professor Mary Christina Wood drops by to tell us what's going on with the what's called the Juliana case, the young person's lawsuit against the federal government. Check it out, leave your comments, ding the bell, share it with your friends, and subscribe to our channel. On the line with us is Mary Christina Wood. She's the Philip H. Knight Professor and Faculty Director, of the Environmental and Natural Resources Law Center at the University of Oregon School of Law. Go Ducks! The website law.uoregon.edu or ourchildrenstrust.org, actually, more importantly, because she came up with the legal theory, in fact, wrote a book about it, that was used in this, in the lawsuit, the Our Children's Trust, or also known as the Juliana lawsuit, against the federal government, saying that basically you guys are taking away our futures. Mary, welcome back to the program.
Thank you so much. It's a pleasure to be on.
Great having you back on. It's been a while, so if you could just recap for us, first of all, the rationale for this lawsuit. How, what is the legal theory that you're using in layman's terms to argue that the federal government, to argue what you're arguing? In fact, you need to define exactly what you're arguing as well.
Yeah, first I'll clarify, I'm not involved in the litigation. I write about and speak about it, but I'll characterize what the lawyers in the case are arguing. Basically, the case is brought on behalf of 21 youth plaintiffs, and they are arguing that the government's fossil fuel policies are endangering their prospects for survival in the century, and that by bringing the nation to climate disaster, the federal government is violating two sets of rights. One, under the Due Process Clause, their rights to life, liberty, and property. And the second is under the Federal Public Trust Doctrine, which is a principle that dates back to Roman times, that requires government to protect crucial resources for the citizens' survival.
And that was that was the theory that you brilliantly laid out in your book, as I recall.
That's right. I focused on the public trust. This lawsuit is actually bringing the constitutional claim as well under the Due Process Clause. Right.
Now, the headlines last week were that, youth climate lawsuit shot down by the Ninth Circuit Court, and much of the press was treating this as if it was dead. What actually happened?
Well, it's not at all dead. There's a second step with the Ninth Circuit. That is the plaintiffs, the 21 youth, have vowed to take a petition for en banc review. And what that means is they will ask the full court to look at whether the case merits further review by an 11-member panel.
Because originally it was just a 3-member panel that ruled against them. And it was only 2 out of 3 of them.
It was a divided panel.
Pardon?
It was a divided panel. There was a very vigorous dissent. So the plaintiffs will ask the full court to look at this case and say whether or not it deserves further review. If it does, and they get a majority of judges voting to give it further review, then they will have an 11-member panel look at the case, and that panel can change the original panel's decision.
And then if the Ninth Circuit rules in favor of the young people and saying, the federal government has an obligation to provide you with a future or not to steal your future, then it goes to the Supreme Court. Do I have that right?
Well, maybe not. It depends. Mm-hmm. If the en banc, as we call it, the en banc panel ruled in favor of these young people, they would send it back to trial. And the trial has never happened in this case. So, of course, the other party, the government, could appeal it to the Supreme Court of the United States, but they may not. It depends how the opinion is worded. If it's very, very narrow and represents a narrow victory for the plaintiffs, conceivably, it could go back to trial. When I said it never had trial in the first place, that's a very important point because most cases go to trial and then to the appellate body. This case never had that. This case was taken up on premature appeal. So there was never that fact-finding and development of a potential remedy, and that, I think, really shaped the panel's treatment of this case because they said, we just can't envision a remedy in this case.
Right, so
Normally, remedies are crafted by the trial judges.
Forgive my interruption. So essentially what the federal government is saying is, how dare you want to have a trial on this? We don't even want to discuss this in court. We're going to challenge your right to have a trial around this. Is that correct?
Pretty much. They did everything they could to prevent a trial. And again, most cases go to trial. That is the sequence of our judicial system. You put a case into trial, and then you bring an appeal so that the appellate court has a full factual record to assess the law against.
Right.
But in this case, the federal government, the Trump administration lawyers, were so, they just pulled out all the stops to prevent a trial, and they finally succeeded and got this premature appeal to the Ninth Circuit. Well, that sent the whole question of remedy, which we can talk about, sent it to the panel as an abstract hypothetical. So the panel's opinion that came down a week ago now really was hung up on the question of remedy, because the panel couldn't envision any sort of tangible set of circumstances where the court would be appropriate in granting relief.
So what remedy are you seeking? The remedy is I guess it's self-evident. What remedy are you seeking?
Well, the plaintiff's attorneys seek a remedy that has several different components. One is they had an injunction in front of the Ninth Circuit to stop certain classes of further fossil fuel projects, and that's really important because we're so close to the tipping point that literally any more fossil fuel projects could put us over that climate cliff. And so there was a clear request for injunction to stop those projects. That's a pretty traditional form of relief. Mm-hmm. Another thing they asked for was a declaratory judgment, just the court declare that the government was violating these young people's constitutional rights. But what really got the court was their request for a plan, a court-supervised plan to decarbonize the economy and bring CO2 emissions down. And of course, those plans have been used. Plans have been used in other cases of institutional litigation, like the Brown v. Board of Education, the prison rights cases, educational funding cases, all sorts of.
Well, even the tobacco cases.
Maybe a little bit less so, because those cases weren't against a government institution. But the point is that judges do craft relief for plaintiffs that suffer injuries. But this panel said no. They said even though we're being driven towards apocalypse, they literally used that language. The panel's opinion started out saying this is basically the eve of destruction. And they said that the federal government has known for decades what kind of catastrophe it would cause. They even admitted this could be the end of the nation. And yet the majority said the courts have no role in providing any relief. Go look to the political branches to find any relief.
So basically what they're saying is this should be the responsibility of the legislative branch, not the judicial branch. You're talking to the wrong people. You should be talking to your legislators. Is that what the court?
Well, pretty much legislators and the Trump administration.
Right.
And yet
good luck with that.
They do acknowledge very forthrightly that the current administration is just driving up fossil fuel production faster than any other country in the world. Mm. Judge Hurwitz, who wrote the majority opinion, said carbon levels have, this is language, skyrocketed to levels not seen for almost 3 million years. Mm. And oil and gas extraction here in the United States is happening 4 times faster than that of any other nation, and we are approaching, in his exact words, the point of no return.
And this is the guy who said, no, this case can't be decided by us.
Correct.
So I'm guessing the dissent that said we should decide this case was even more blistering.
Well, yes. So the dissent starts her opinion. This is Judge Josephine Staten, who is a district court judge sitting by designation on the Ninth Circuit on this panel. And she began her dissent saying, it is as if an asteroid were barreling towards Earth, and the government decides to shut down our only defenses. The government bluntly insists it has the absolute and unreviewable power to destroy the nation. My colleagues throw up their hands. So in her mind, the courts absolutely have the duty to prevent willful destruction of the nation.